Well, staying with the pandemic, students' experience of university during COVID restrictions was very far from normal. Instead of being on campus, in libraries and labs and attending lectures, most spent their time alone facing a computer screen. Undergraduates, nonetheless, were paying over £9,000 a year in fees. Now, over 80,000 graduates have joined a mass legal action against universities demanding refunds for the quality of their teaching during lockdown. Ryan Dunleavy from the law firm Harkers Parker is leading the action, and David Hamon, who is a student, is also part of the claim. David, do you want to tell me a little bit about your experience of lockdown?
Of course. So I did a one-year's master's right in the middle of the pandemic at UCL, and it absolutely was not what I was sold. Sort of studying a master's in international politics at London's global university is supposed to be a space for people from all different backgrounds, different experiences, cultural perspectives to come together and to share and exchange and to carry those perspectives out into the world. And what we ended up with was online seminars where nobody spoke. And the reason for that is it's just nearly impossible to generate the sort of environment in an online seminar where people feel comfortable to share controversial opinions. For that, you need the space in between the seminars. You need the social interaction to build trust and to build those networks to then carry out into our careers. That's what the universities market themselves with.
Absolutely, I entirely see that. Why were the universities to blame? They didn't create the pandemic.
No, they didn't. And nobody's trying to blame the universities, but the fact is that the universities saved money by moving tuition online during the pandemic.
Can you quantify that?
And we lost out on our experience. No, I can't quantify that. They haven't made the statistics available. But we lost out on the experience there, and we were promised a service. There was a decision made in the UK to make education a commodity and students consumers. And we are burdened with enormous debt where we can barely pay off the interest each month because of that. And it has to work both ways. If we are made into consumers, then we have consumer rights and we're allowed to assert them.
It seems to me, by the way, sticking with you, David, just for the moment, that this goes back a little bit further. You talk about being made into consumers, but funnily enough, you're not in this sense, that this is the only field in which good products and bad products all sell at the same price. A Rolls-Royce and a bicycle do not sell at the same price. But in university education, the worst course at the worst university sells at the same price, I think broadly speaking anyway, as the best course in the best university. I mean, that's mad. There's no market there at all. You're not consumers at all.
Well, I know, but we should be, and that's the way that the policy was designed. The £9,000 fee cap, of course, there's no cap on master's tuition, so I paid much more. But the £9,000 is supposed to be a cap, and there's supposed to be a competitive market underneath that, with universities competing for students and pushing up their standards. It's clearly a sign of a failed model that cap is actually just a price that all universities stick to. And it's a sign of a failed model that the lecturers are striking at the moment, for example. It means that the financial pressures on universities are unbearable, and clearly the model doesn't work in the way that it was designed.
Ryan, what hopes do you have of this action?
Oh, I'm expecting it to succeed. I wouldn't be doing it on a no-win, no-fee basis if I thought differently. We have a large team of solicitors working on it at two different law firms. We have a team of barristers working on it, including King's Counsel. We're very confident that it's going to win.
The question I put to David a moment ago, did the universities save money?
It's not so much that they saved money. What they did was, because they weren't constrained by lecture theatres and resources in terms of physical resources, they actually massively increased their student numbers and their fee income from students. So, for instance, UCL, which is the university David went to, increased their fee income by 41%. King's College London, even more, by 48%.
During the pandemic?
During the pandemic. So every university that we've written to so far has increased its fee income massively, but we're seeing this across the board. Not only that, they took furlough money and they saved money from not having to pay for heating and other expenses. It's much cheaper to regurgitate the same lectures 2 years in a row on Zoom than it is actually to provide the service that they were paid for.
So some people who might be worried, Ryan, that this is going to bankrupt the universities and that won't do anyone any good, you would say absolutely not. This is money which is sort of swilling around in the system.
Absolutely. The first 18 universities we've written to have a £1 billion surplus from the pandemic, and they have more than £16 billion worth of assets. Whereas you compare that to the students, they have loans, no assets, no income. You know, who's the vulnerable party here? It's not the universities.
In case anyone's been wondering what UCL is, it's University College London, and we contacted UCL for a response, and it gave us this somewhat lengthy statement. We have a well-established complaints procedure which gives students the option of complaining to the Office of the Independent Adjudicator for Higher Education if they're not satisfied with our response. We believe this process represents the best, most efficient and swiftest way for our students to resolve any complaints. In proposing this, we're not suggesting that students should not be able to seek access to the courts, but given that they've not yet used appropriate and available ways to resolve their complaints through our established processes, the group litigation order is unnecessary and premature. During the COVID-19 pandemic, UCL prioritised the health and safety of our whole community and followed UK government guidance. Our lecturers and support staff worked tirelessly to make our campus and all UCL premises as safe as possible and ensure that a high-quality academic experience was provided to students. Ryan, basically what that says is you should go through internal procedures before you go to law.
Which I can understand why that's very tempting for UCL to say that, because it makes it the defendant and the judge. So far, though, I mean, we've seen very, very inadequate responses from universities across the UK. There are more than 2.5 million students who are affected by this, and I think the Times ran a report last week saying 1,300 from its Freedom of Information requests actually got compensation. We don't know the value of that compensation. But so the Times are saying fewer than 2,000. I don't know if that's correct or whether it's more than that, but we're talking it's going to be in the low thousands in comparison to 2.5 million plus students who are affected. And also, you know, these students have a right in law to go to court. So Article 6 of the European Convention on Human Rights gives people access to the courts, and there's a well-established case called Halsey, which has been challenged in the past by other institutions that have tried to get round people going to court and having their day in court and exercising their actual rights. And no doubt the UCL is intending to do exactly the same thing. I expect it not to wash in the courts.
David, UCL there in its last sentence claiming that you'd had high-quality experience. What's your reaction to that?
Well, that's exactly the point. So we actually tried to complain to UCL while we were there. We wrote a letter and it was signed by over 150 students, and we sent it in, and that was exactly their response. At a time where we were locked in rooms in silent seminars, many of us, having come from across the world, paying twice the fees that I did, paying thousands of pounds a month for tiny little rooms in central London in rent, because UCL had encouraged us to come to London. And they claimed that the standard of education that they were providing was the same, and we were living it at that time. It was quite frankly, a horrible experience, and it was not what we were supposed to be delivered with.
Ryan, the law's delays, how long might this take?
Well, it depends on... It's a three-stage process. So the first process is UCL trying to block the students from actually being able to access the courts, which is firstly outrageous and shouldn't be allowed. We expect that hearing to take place in the next month or so. It was supposed to take place last week, but for administrative reasons, the court moved it to another list effectively in the court. After that, there'll be a liability hearing, at which the UCL will be required to say whether... the court will say whether UCL is required to pay compensation or not. After that, there'll be expert evidence on valuing the claims. Now, UCL can settle at any stage, and 99% of cases in this jurisdiction do settle out of court. So we would like to have some sort of a dialogue with them where we can effectively find some sort of redress for the students without having to go through this process. Even though I'm a lawyer, I'm not trying to push it through the courts. That's UCL. It filed something on the 27th of January saying it admits zero liability. So if it's doing that, I would also question what its own internal complaints procedures would be like.
And if a student hasn't joined in this claim, will that student not be entitled to any money back should you be successful? No. In other words, should students now be signing up?
Yes, they should go to studentgroupclaim.co.uk and sign up, because otherwise they're not entitled to any money from this litigation.
And when I say students, I probably mean graduates, because by now those people will have moved through the process. So Ryan Dunleavy and David Hamon, thank you.